Good morning, everybody. Thank you again for joining me this morning. I am Victoria, one of the estate planning attorneys with the Koppenberger Law Firm. I primarily do work out of our Northern California offices. So if you are in San Jose, Santa Cruz, or Sacramento, likely you will be seeing me. If you are in closer to one of our Southern California offices, we do have quite a team of attorneys that I would be happy to introduce you to. All right, so we are going to cover quite a bit of information today. It can seem like a lot, and especially if you have no understanding of estate planning, this will be a great crash course, but often it leads to more questions than answers by the end because it is quite a bit of information. So again, feel free to use the chat or the Q&A to ask questions throughout, or again, making an appointment at the end so that we can address your questions more directly. So we're going to go over what is a comprehensive estate plan and how to establish it. So essentially, if you do not have an estate plan, it's going to outline what your estate plan should probably consist of. And if you already have one, it's a really good review to make sure not only that you do have these documents, but also why they were so important. We are going to cover how to protect yourself from avoidable disasters. So unfortunately, one of the things we often see from other trusts that are done is that clients bring them to us, they've had them done somewhere else, and there were things that we could have avoided, but now we are having to clean up. So we want to make sure that you have that information ahead of time so that we don't have you in those situations. One of the big conversations today is definitely about incapacity, conservatorships, and long-term care needs. This is becoming a bigger and bigger issue the longer we're living, and just the statistics around the need for long-term care are rising. And so this is something we will definitely be focusing on today. One of the other big things that has happened in the past about now 3 years is there have been some law updates. And so we want to make sure you are aware of what those entail and make sure that you have some idea of what you may need to address within your own estate plan. Another big component of what we'll talk about is how to leave a lasting legacy. So our founder actually started this firm with the idea that every client's legacy matters. That doesn't matter if it's financial, emotional, whatever you want your legacy to be, it matters. And there are various ways that we are able to help you either establish one or figure out how to convey that to future generations. And then ultimately, why should you work with us out of all of the other estate planning attorneys out there? So let's jump in first and foremost to what is involved with your comprehensive estate plan. So if you have an estate plan through us, generally speaking, you will have each of these documents. Now I'm going to cover them more in detail in just a second, but essentially when you're looking at your estate plan, if you do not have one of these or you're questioning if you do, absolutely come and talk to us. Each of these documents has its own importance, and to only have one or even just one or two of them could still be leaving you vulnerable in areas that you do not want to be left vulnerable in. So the healthcare directive is dealing with health. Your durable power of attorney is dealing with finances, and then your pour over wills and living trusts are dealing with actually a combination of the two. So let's look even closer at what these actually involve and entail. So your healthcare directive is actually the document that gives a person authority to act on your behalf for healthcare decisions if you are no longer able to do so. So in some cases, the issue that we're addressing here is you're incapacitated and you need to put in writing who can actually make those decisions. The reason this is important is back in 2004, the law did change to say that nobody has an automatic right to make decisions on your behalf. It has to either be conveyed to the doctor verbally or it needs to be in writing. So that's a big component. The other thing is actually putting in writing what decisions would you want made. So we talk about organ donation, life support, things of that nature, so that not only do you still have the ability to control what happens to you, even if you can't communicate it, but it also relieves a lot of the guilt and pressure and stress that can come from trying to guess at what someone would want. It's sitting there in writing for them to follow and know that the choice they're making is actually just representing the choice you had already made. So if you are over the age of 18, or you have kids that are over 18, or anybody in your life that's over 18, this is one of those documents that you should not delay getting set up. It's a fairly simple document to put in place, but it has an astronomical value and a lot of protection that you just don't want to play around with. So again, if you don't have yours, now is definitely the time to come and talk to us to get this put into effect. A similarly important document is your durable power of attorney. Now, I mentioned a few slides ago that this is dealing with finances. So this is saying that if I became incapacitated, who could actually manage my financial matters on my behalf? So again, we're dealing with, you're in a position where you're vulnerable, you don't have capacity anymore, but that doesn't mean that bills have stopped. So you need somebody to have the authority to actually use your finances and your resources to continue to pay bills and manage your estate on your behalf. Again, this is one of those that if you do not have it, do not delay putting it into effect. Again, it's a fairly simple document for us to get prepared. But when I say simple, that does not mean it has little protection. In fact, it's the exact opposite. This is another document that has more protection than often people realize until they actually need it or until they realize they do not have it. So this is, again, something that you really should not delay on. Now, a lot of times people use wills and trusts interchangeably. So especially if you watch any movie or TV show, more often than not, you hear will and not trust. But this can then lead to some issues for people who think all I need is a will. That may be true if you are somebody with no real estate, if you have less than $166,000, and or you are the parent of a minor child. Now, if you are the parent of a minor child, you will have a will regardless of whether the other categories matter or not, because this is where we actually name guardians of your minor children. But if you own property, or if your estate is greater than that $166,000 number, a will is not adequate to fully protect you in your estate. And the reason for that is, if you do not fall in those categories, your estate when you pass away would be subject to probate. Now, probate is a court process that follows state rules, and it is there to actually settle accounts with the living, settle the accounts of the decedent, and ultimately to transfer title from decedent to their heirs and beneficiaries. So you can take a property, for example. If you had a will and you owned a piece of property and you passed away, that property now has to go through probate. And let's say you owed a mortgage still on that property. Well, through the probate process, that mortgage would be paid off prior to it transferring to your heirs or beneficiaries. And so this is something that the court then controls. Now, again, it is an actual legal process following state rules. If you have ever dealt with the court, or government, frankly, you likely know that expedience and efficiency is not generally what it is known for. And so probate in particular can cause very lengthy delays in actually settling someone's estate once they have passed. Especially due to COVID, we used to see that this could take about anywhere from 2 to 3 years. I spoke with someone recently and she was in her 7th year of dealing with the court and an administration. And so this is something that truly can cause, when I say lengthy delays, I really mean lengthy delays. You don't want to have to deal with the court 7 years after somebody has passed away. At least I sure know I would not want to. Part of the reason for those lengthy delays is because the control is with the court and it's on their calendar. So you don't get to dictate when things are done, the court does. One of the other big issues is the cost of probate. So you'll see at the bottom, it says 5 to 7% of the gross estate. What that means is they do not care what your equity in a home is, they care what that property could be sold for. And that's what that percentage is put on. This seems incredibly unfair, and I don't disagree with that at all. But unfortunately, again, it's state rules. And so that is something that they will apply. We have seen probates where all they had was $1 million home. There was very little or no cash, and they were still ending up paying around $40,000 by the time all was said and done, sometimes more. So again, this is not something to take lightly. Now, the good news is there are ways to avoid probate, and the biggest one is by using living trusts. So this is what we specialize in. Trusts are our bread and butter. So a trust is a contract between who is called the settlor and the trustee. Now the settlor is who actually sets the contract terms. So if you are the one coming to us and setting up the estate plan, you will be known as the settlor from the time you set it up until the time you pass away. You are likely also going to be the initial trustee. And as that role, you'll continue carrying out your own wishes. But at some point, the trustee is a role that shifts. And so whoever would be what's called your successor trustee is responsible for carrying out your wishes, not their own. So again, this is a contract. And so if someone is in that role as trustee, they don't get to make their own decisions. They really do need to follow whatever you have set out are the guidelines and rules. Now, I'm going to say this quite a few times during this presentation, and if you become one of our clients or you already are one of our clients, it's really important to note that a trust only protects what it owns. So we have a lot of clients, unfortunately, where they come in and set up a trust and then they do nothing else. What we tell every single client is just because you have set up a trust doesn't mean your homework is done. What you then need to do is transfer certain assets into the name of the trust. Now, this can seem very confusing until we start breaking it down by client instead of talking about this more globally. But essentially, there are some basic assets that just need to be in the name of the trust. Your property is one of the main ones. But essentially, if you're sitting here and you do have a trust and you're not sure it was properly funded, please come and talk to us. And if you don't have a trust yet and you work with us, trust that we will say this to you probably a good 6 or 7 more times before we're done. Now, I somewhat covered this on the prior slide, but a settlor is essentially a fancy way of saying the creator. So again, whoever creates the trust, that's them. It doesn't shift at any point. The trustee, though, again, is who actually manages and invests the trust assets and follows the terms of the trust. So if you as the trustee became incapacitated or even passed away, you do need to have somebody in line to take over on your behalf. And this can be a very complicated conversation for some of our clients. And so if you're sitting here and you go, I have no clue who I would trust to be in that role, we have a lot of good ways that we can help you brainstorm ideas and come up with alternative solutions. Now, when you first set up the trust, you are also likely the initial beneficiary. It's your asset, it's your money, you should be the one to benefit from it unless you specify otherwise. But ultimately, you will have named someone for when you pass away. And again, this can be a complicated conversation depending on the structure of your family or where you want your estate to ultimately go. All of that is to say that every estate plan that we do is going to be customized per client. So while there are certain sections of our trust that are going to be the same throughout every trust because it's the law, everything that has to do with you is unique to your situation. So again, whether you're sitting there saying, I have a simple situation, or you're going, mine seems more complicated than it's worth, do come and talk to us, because at this point, we've pretty much seen the gambit of scenarios, and so we are able to assist. Now, if you didn't catch, one of the biggest benefits of a living trust is that it can avoid the cost and delay of probate. One of the other big advantages, though, is that it does protect your privacy. So if something has to go through probate, it does become a public proceeding, which means pretty much anyone who has interest could see what was going on with your estate. Versus with a trust, the only people who see it are the ones that are actually entitled to it and the ones you have designated that should see it. One of the other benefits is that it allows tax planning. So if you are concerned about how do I protect my estate from unnecessary taxes, do I need to be concerned about paying taxes? We have plenty of trusts and options to allow you to either completely eliminate taxes or at least reduce it to the very bare minimum it would have to be. One thing we are also going to talk about today is conservatorships and the importance of trying to avoid the need for one. And a living trust is a fantastic way to avoid the need for a conservatorship. But ultimately, and I will keep saying this, whether it's today or when we meet with you in a consultation, it's your wishes that we are making sure are carried out, not anybody else's, not the courts, not other family members, no one's except yours. But again, a trust only protects what it owns. So I mentioned that one of the things that should be in the name of your trust is any real property that you own. But generally speaking, that will also include checking accounts, savings accounts, and non-beneficiary stock accounts. Now, the good news, though, is if for some reason you forget to do this after you've set up a trust, we do create what is called a pour over will. This is essentially a safety net for your assets. So the pour over will, whether you have a trust or not, you will end up with a will. If you have a trust, you get the pour over will because it actually accompanies the trust. It essentially says that if an asset should have been in the trust when you passed away is not in the trust, it tells the court to scoop it up and give it back to the trust. That way, rather than the asset having to go through a full probate or having the court dictate where it goes back to your trust and the trust will dictate where it goes. Again, we are trying to keep everything in your control and go where you had ultimately wanted it to be. So again, all of these documents I just talked about generally should be in your estate plan. So if you've worked with an attorney who has not done all of these for you, absolutely come and talk to us. And if you're starting from scratch, just know that these are documents that will be established on your behalf. Now, one of the other things that we offer within our trusts is talking about letters of instruction. One of the biggest things that we're addressing with letters of instruction is how to actually distribute your personal property, so your stuff. That picture shows the house exploding with things, and that is exactly what we're addressing with that letter of instruction. Some of our biggest fights after somebody passes away is not actually over the money, it's over the thing. Because while someone's alive, we say, well, I don't really want any of the stuff. It doesn't really matter to me. But it's because we still have the person in front of us. As soon as someone passes, all of a sudden those things are what actually carry that emotional value. And so we have numerous ways of helping families avoid any unnecessary conflict in the future by helping you designate items that someone may have an emotional attachment to. So again, if you have any questions on this, please do come and talk to us because this really is one of the most important pieces that can be often overlooked amongst all of the other conversation that happens. So now let's jump into pitfalls to avoid. So there are many, and there are many more than are going to be in this list. One of the worst, though, is having the wrong type of trust. What I mean by that is estate planning is its own life cycle. So for some of our clients, when they first came and saw us, they didn't have kids or they had an estate of a more modest size. Well, okay, now 10, 15, 20 years has gone by and they have minor children. Their estate has grown. If you live in Silicon Valley and work in the tech industry, it doesn't take that long if you have any options to stocks to all of a sudden accumulate quite a bit of wealth. But they never came back and saw us. Well, now the issue that could happen is they're paying unnecessary taxes. If God forbid something happened to them while their kids were still minors, now the children may have to go through a court-appointed guardianship, which is its own nightmare to deal with. There's various issues to not having your estate plan kept up to date and having a trust that no longer suits your needs. So as a general rule, we recommend, whether you actually need a change or not, that you come in and have us review your documents every 3 to 5 years. For many of our clients, they do not need changes in those 3 to 5 year windows. However, it gives them and us the reassurance that not only do they have the proper planning, they have the proper people named, and we double check that you have properly funded that trust. So there are so many reasons to really keep in that 3 to 5 year period. Another big issue is not addressing incapacity. So one of the most common things I see when I review trusts prepared by other attorneys is they do not have what are called competency determiners. That is something that is incredibly important to have in your trust. It seems like a very simple role, but basically it is a person who actually determines, can you still serve as a trustee? The issue with not having people named that know you is that unfortunately then for others, they're ending up in front of a judge who is determining whether or not they can still serve as their own trustee. Again, we are trying to avoid court. And so this is something that if you've had a trust prepared by somebody other than Koppenberger, I'd recommend that we do review it just to make sure that either you do have these already, or if you don't, that you have the choice of putting them in. We're also very passionate about Medi-Cal planning and veteran benefits planning. So with veteran benefits, a lot of times this is just assisting veterans in what are their benefits and how to fill out the forms. With the Medi-Cal side of things, we're actually talking about two different components. I'm going to talk about what we call our long-term care protection plan a little bit later in this presentation. But right now, I'm going to talk about a power that we put into our revocable trusts. So within our revocable trusts, we essentially have a power that says, if I needed advanced planning to provide protection, if I needed long-term skilled nursing, but can no longer sign documents, either my spouse or successor trustees could actually establish advanced planning to protect me and my assets. Now, that's going to seem confusing before I talk about the trust in a little bit, or before we actually sit down with you, but this is a very important power that almost no other attorney in California even knows about, because this is something that we specialize in here at Koppenberger. So if you or a loved one is concerned about either long-term care today, or you have that concern that at some point in your life we may need it, do come and talk to us, because depending on where you're at and which phase of life you're in, we can address those concerns in varying ways. Another issue is not adding protective provisions to benefit your family. So there's concern about, if I pass away, what if my spouse remarries and gets a new family? Are they going to then cut my children out? Or how do I protect my estate or my children's inheritance in the event they have their own creditors or they get divorced? What if I have kids that are more contentious and would potentially fight in court and want more money than I've given them? We have what's called a contest clause that basically says if you go to court to fight for an invalid reason, such as greed, and you lose, you are completely disinherited. Now, for a lot of families, this is never something they have to be worried about. But frankly, if you have a family similar to mine, this is something that some of my relatives would potentially trigger if they were not careful. So that can be an important piece depending on your family situation. And then what about substance abuse? So one of the other things we do address is, in the event a beneficiary had a drug or alcohol substance abuse issue, we do have ways to protect them and still leave them money that can be used on their behalf, but that they do not actually have access to. Again, all of this is to say that there are a lot of different scenarios out there, and your trust is able to be essentially composed of whatever protections you need. Now, some of the other huge issues we see are people who actually try to create their own trust, or they write on their original documents, or they try to change it themselves. All three of these are going to lead to issues almost without a question. Creating your own trust is just, it's not a smart choice, because trust law is more complicated than a lot of people and even other attorneys think. And so by creating your own trust, you often create more of a nightmare situation for down the road than you're actually addressing. The next 2 points kind of are combined. We have some clients who question why they can't just write on their documents or do their own amendment. And the main reason is, if you're going to change your documents, it has to be done formally in almost all circumstances. And if it's not, a lot of times it will not be valid, or could even invalidate the entire document. So with this, it's essentially ask first. If you don't know if you can change a portion of your trust on your own, we would much rather hear from you and advise you one way or the other than have to clean up a nightmare situation in the future. This is something so simple, but that can cause some pretty disastrous situations down the line. Again, I mentioned that estate planning is a life cycle. So as your life is changing, again, it's important to make sure that your plan is keeping up with your life and that it's properly protecting you and those you care about. And then again, not funding your trust properly. So I mentioned, I will say this numerous times, and the reason is this is one of the biggest issues, even for our clients, that we do see occur. They leave our office after signing their trusts and they just forget, or enough time goes by that it just falls out of their head because life happens and people get busy. It's very common. It happens all the time. And so our job then is to continue to remind you, make sure that that got done so that you really are properly protected. A few other issues we see. One big one is naming co-trustees that do not think alike. So I mentioned your trustee is in charge of actually carrying out your wishes. And I've had some parents in particular question or ask, can I just name both of my kids? My first question back to them is, do your kids get along? And then, do they think similarly? The reason we ask this is those fights that your children had when they were kids over toys, generally speaking, are only exasperated now when they're dealing with grief and money management. And so if your kids get along splendidly and they think similarly, there's no issue. But if you tell me, well, no, they really don't see eye to eye, or they do have issues, then generally we're advising, do not name them together, or there could be issues down the line. Having incorrect distribution language or the wrong successor trustees can again also be issues. No protection against beneficiaries fighting. So I mentioned that contest clause, and that's one of the main ones that we use. Another issue is just leaving inheritance outright to minors. Now, when we're talking about minors, we're not only talking about those who are 18 and under, but we're actually talking about any age you ultimately decide. Some people are not comfortable with the idea of, if I passed, my 18-year-old could potentially inherit millions. So for some people, they don't want their child actually inheriting it directly until they reach 25, 30, sometimes 35 or older. It doesn't mean the inheritance can't be used for them. It just means essentially they don't get to use it themselves until they reach whichever age that you deem appropriate. One of the other conversations we have is your beneficiary accounts. So your beneficiary accounts, whoever's named, is going to take priority over the trust. And so one thing that we also mentioned in our signings is, just because you've established a trust with beneficiaries, you still need to make sure that the people you've named on those accounts are going to match who you would want. This can be a much more complicated conversation. So if you have questions on this, or during the consultation process need to ask more, please do not hesitate to do so. Now, one of the other issues is blended families. Now, in some blended families, they have zero concern about where the estate's going to go. They're on the exact same page. But I would say equally as common are the blended families where they are not on the same page. This could be because sometimes the kids of one do not like the new spouse. You are my second mom, you're not my actual dad, whatever the issue may be, that can be a problem. And or you've brought assets in from before and you want those to go to your respective kids. So a lot of times we hear, your kids are the problem, my kids are wonderful, and our kids are wonderful. Essentially, every single family is different. And so depending on your blended family, you may need more advanced protections to make sure that your respective wishes are carried out and that there aren't issues down the line for the surviving spouse or for the ultimate beneficiaries after both have passed away. So in this, we're really looking at protecting all parties involved from conflict down the line. So if you do have a blended family, whether it's a simple blended family or a more complicated blended family, whatever that looks like, your trust can provide protection for you. Now, I'm going to use two examples of people who are a little bit more on the famous side. So Prince actually never created an estate plan. One of the big issues here is then his estate has to go through probate. So not only does that mean they're fighting it out in court and it's public, but it also means it's going to take a fairly significant chunk of the estate. So now most of us are not dealing with a $300 million estate. However, that can actually then be worse when it comes to the probate fees, because we have actually had some probates where, because of the debts owed, the kids actually walk away with little to nothing by the time all is said and done. So regardless of the size of your estate, avoiding probate is one of those things that we just encourage you to do. Whether you have $100,000, well, I'll say $200,000, all the way up to the $300 million mark, that is still going to be important to protect regardless of where you fall within that spectrum. Now, not as many people know about Paul Walker. He was the actor from the Fast and the Furious movies. And while his estate did have to go through probate, we were actually more concerned in this case about what had to happen with his daughter. So he had an out-of-date estate plan that did not include his daughter. Unfortunately, if you have a minor child and you pass away with a plan that does not account for your minor children, they technically become wards of the state. Now, I had someone ask me very recently, why wouldn't they just automatically go to another family member or to their other parent? And I said, well, the issue is that may not be the right person. If you were in a divorce because your ex-spouse was abusive, doesn't matter that they're the child's parent, it's probably not the right person to have that child now go to. Or what if a family member just cannot afford to raise a child? They don't have the means. Whatever the situation is, we want to make sure that you have addressed it so that your child can go where it is appropriate for them to go to, not become a ward of the state and the state ultimately have to dictate where that child goes. So in his case, it was incredibly heartbreaking that his daughter was left, at least for a time, vulnerable. Now, he was in a better position because he was wealthier, there were people in the area. You can account for that to a degree, but again, this is a scenario that is so avoidable. And even if you have a 1% chance of a nightmare, let's not let you potentially risk that 1%. All right, so that was a lot, but now we're going to turn over into incapacity, conservatorships, and long-term care. So to start out with incapacity, I'm going to more focus actually on just general things that we see, some warning signs to pay attention to, but also how to take care of yourself as a caregiver. So one thing to know is that if a loved one becomes incapacitated, not every day is a good day. There's a lot of added stress for the family and for yourself, and it can be really hard for the person who now needs to potentially move to new care facilities to adjust to that home life. Now, the last 2 points on this screen are important because these can be some of the more early signs of Alzheimer's or dementia. I spoke with a lady not that long ago, and as she was describing issues with her husband, she thought it was something else, but based on what she was telling me, he very much sounded like someone who had early onset dementia or Alzheimer's because he was becoming paranoid. He didn't want to cooperate. There were other things as well, but those were some of the telltale signs. So we emphasize these just to say, if you do have a loved one where they are showing signs of paranoia, suspicion, or just not willing to cooperate, they may be showing early onset signs of those diseases. Now, we focus on the caregivers because while we very much want to take care of the one who actually needs the care now, caregivers are often overlooked, or they feel like they're alone, or they don't know where to turn. And so one thing here at Kopp & Berger we're very passionate about is the entire family, not just the person who actually needs the care now. And the reason for that is, again, caregivers often have no clue where to turn. They all of a sudden are just physically and emotionally exhausted. They're having to manage somebody else's life. It means you're really never off the clock because, again, emotionally, you're still going to be thinking about that person. There's so much that comes with it that it can absolutely feel overwhelming and you don't know where to turn. So it's really important to note you actually take care of yourself first. I use the airplane analogy all the time when I'm talking about this. When they tell you to put your oxygen mask on first before helping anyone else, the reason is you can't help anybody if you have nothing left to give. So as a caregiver, and I've been in that role for my own father, it can feel selfish at times to say, I need a break or I need to take time for me. But the reality is you have to do that. Now, one of the ways that Kopp & Berger helps is by assisting those who do have that caregiver role in finding other types of professional help. So here at Koppenberger, we have quite a network of other professionals that we work with. And so if all of a sudden you're having to file someone else's tax returns, we have CPAs for you. You don't know how to manage the finances for this person, we have financial advisors. If you need therapy or any other kind of medical help, we have referrals for that as well. Again, we emphasize this because we look at our clients as their whole family and each generation, not just the person sitting right in front of us, even though they are equally important. Now, transitioning over to the person who actually needs the care. Now, if you have not set up documents that I've talked about throughout this presentation and you became incapacitated, a conservatorship may be required. Because if you have not already appointed who would take care of you medically and financially, a court is going to have to do so. Because the conservator's duties are overseeing your finances and your medical or physical care. So again, if you don't have documents already doing so, we have to turn back to the court to put that into effect. Now, conservatorships in some cases are easy to obtain, but in other cases, and probably more cases, we have to go through a more extensive proof process. So we almost always need someone to have a medical evaluation. If you're going through the court, they don't just want to strip people of autonomy or independence without actual reason to do so. And one of the best ways to prove that is with medical evaluations. Witness testimony can also be effective. So if a neighbor's all of a sudden notice that, man, she used to really take care of her yard and everything was meticulous, but in the last couple months, it's fallen apart. There's mail building up. The trash doesn't seem to be going out. That can be some testimony that helps prove the person no longer has the ability to care for themselves. We then have to fill out all the paperwork and actually file the petition with the court. And of course, there are going to be fees associated, so we have to get those paid as well. Now, again, similar to probate, the really good news here is by setting up an estate plan, you can have the ability to avoid a conservatorship. And I cannot stress strongly enough how important that is to do. Since COVID started, we have seen, at least in our firm, a significant uptick in the need for people to file conservatorships. What that means is not only are people not getting their estate plans established, it also means the court is going to be more delayed. On average, our first hearings are not happening for about 6 months, sometimes even longer after we file that petition. And so in the time we're waiting, a lot of times the people who need the care are left vulnerable because the person that wants to care for them does not have any authority to do so. So having it in writing through that healthcare directive, financial power of attorney, your trust, or sometimes even a special needs trust is how you avoid a conservatorship and make sure all of that is set up before a crisis is at hand. Another huge concern right now is the fact that people are scared of becoming ill. And one of the other issues is we are seeing the number of people who need long-term skilled nursing and who are becoming ill actually increase. With that being said, it means the cost, unfortunately, is also increasing. If you live anywhere in California, but especially in the Bay Area, you're likely very aware, unfortunately, that things do not generally get cheaper in this state. In fact, it's the exact opposite. They grow by an astronomical amount. And that is absolutely what we are seeing with skilled nursing. And so this is something that we've been addressing for quite a few years, but is definitely one of the prime conversations we have with a majority of our clients at this point. So the issue right now is, again, there's a rise in age-related illnesses that can last years. We are living longer, which means not only are the diseases developing in more people, but we're living with those diseases longer. And so the question becomes, how do we protect your estate from loss due to that illness or incapacity? How do we find you the right care? But also, how do you find the way to actually pay for that care? Now, there's a few different programs out there, and often it's very confusing because they have similar names and a lot of times are used fairly interchangeably. So Medicare you will hear about, and that's an age-based program that's really dealing with your doctors, your prescriptions, things of that nature. It's your health insurance. When we're talking about Medi-Cal and Medicaid, those are very similar programs. The difference is Medi-Cal is in our state, Medicaid is in all of the other states. But this is essentially where we're focusing on Medi-Cal paying for the actual facility that you could end up in for long-term skilled nursing needs. So to put in perspective what that cost is, average in California, we have this diagram up on the board now again, or on the screen. Now, again, this is for California as a whole. And so what that means is, unfortunately, if you live in the Bay Area or somewhere that is more affluent, odds are these prices are going to be significantly higher, because this is taking into account Fresno, Temecula, the Bay Area, it's the entire state. And so with that being said, even with the numbers on the screen, you can see how cost prohibitive care unfortunately can be depending on your estate size. So who ultimately pays for the care? Well, it's either you. If you have long-term care insurance, your insurance can cover some or all of it, your children, or the government, which I'm going to talk more about in just a second. So again, the ways you can be looking at paying for it are through your monthly income, the savings you have. Unfortunately, some people do have to sell their home. You have to rely on your family. You signed up for insurance years ago and you can use that, or the government. The thing I'm going to stress today is, how do you utilize that last point? So we have a trust that I briefly mentioned in the beginning that essentially allows you to protect your assets and qualify for Medi-Cal. So a lot of people don't think this exists. They've been told if I needed long-term skilled nursing, I would have to spend everything I have down in order to ever qualify. And that is true unless you have one of our trusts. And so this is where, if you're not ready for this type of trust, we're putting language in your original trust that says, if I lost the ability to set this up for myself, someone else can. But if you are in the position where you're thinking in the next couple of years, you or your loved one may need this, this is then a trust that we recommend establishing sooner than later, because this can end up saving clients, and we've seen it with clients who are using it. This can save them hundreds of thousands of dollars, because again, the cost of care is so astronomical. So essentially, we established this to avoid you having to spend down your entire estate. Now, this trust was originally created because our founder watched a couple where he needed care, and all of the money that the two of them had ended up building over their joint lifetimes completely getting depleted by needing to pay for his care. By the time he passed away, she actually had to she lost everything, and she had to move back with her daughter. This is one of those situations that you can absolutely avoid by using our trust, and you should frankly try to avoid it, because not only are we concerned about your legacy and leaving things where you want them to go, we also don't want you to be giving the government unnecessary money that you worked so hard for. And if you are married, we want to make sure that the spouse who survives still has enough resources to take care of themselves, especially if they end up with some form of medical crisis. So there are so many reasons that this is a type of plan we talk to every client about, no matter if they're ready for this planning or they just need to have the knowledge it exists so that if something happens, they're aware they can still come back and we can assist them. Now, Medi-Cal laws are in the process of changing right now. So one thing to note is the allowances have gone up. So if you've never heard of what the allowance is, that's okay. But for those of you who have, you likely heard the $2,000 number. What that used to mean is that if you were a single individual, you could not have more than a primary residence and $2,000, or you would be disqualified from any Medi-Cal benefits. Well, coming up in July, that's going to be changed to $130,000 plus your primary residence. So that's a significant increase. And so for some people who wouldn't have otherwise qualified for Medi-Cal, they potentially now can with or without our trust. For married allowance, that's now going to be about $195,000. So again, if you're married, that number has gone up a bit as well. So if you have any questions on could I qualify for Medi-Cal today, or how do I qualify, those are things that we're happy to address with you also. But one thing to note is phase 2, that's still a couple years off, but it's important to keep in mind. They are talking about right now getting rid of the dollar figure allowances and switching everything to income. If that happens, as far as what we can tell so far, that income would be significantly lower than what is probably reasonable. And so this is again something that if you're concerned about needing care in the next 2 years, do not delay talking to us. But if you're not at the phase of needing that kind of care, just be aware that in 2024, we'll be updating you again on what the new laws surrounding Medi-Cal entail. So how does this actually affect you? Well, qualifying for Medi-Cal is very complex often. If you've ever worked with anything that regards disability or getting benefits regarding disability, you often know then the forms they send you can be confusing and they don't often set you up for success. I had to fill them out for my father for disability through his work, and they would send forms that had simple just yes, no questions with no explanation available. And so for him, he would check yes to, can you vacuum? Well, what they're trying to figure out is, can you work? And so he's sitting there checking yes to every single thing and saying, yeah, I can do all of these things. And he got denied. And I thought, that seems incredibly strange because my father is not in a physical state to work or to really do anything completely on his own at this point due to his medical conditions. So I looked at the forms he submitted and I immediately went, well, this is a little bit ridiculous. And I contacted him and an attorney actually who specializes in this and essentially said, okay, yes, he can vacuum, but what it doesn't let him put is it can take him 8 hours to vacuum because he gets tired, he can get sick throughout the day, he loses his balance, all of these things that lead to, no, he really can't do what they're trying to indicate he can. So again, when you're looking at qualifying for Medi-Cal, the forms are very similar a lot of times. They're trying to disqualify people. And so we're able to assist you not only on understanding what the rules are and whether you can or can't, but actually navigating those forms so that you don't accidentally fall into the pitfalls they're trying to lead you into. Ultimately, what we're talking about for everything, but especially with long-term skilled nursing concerns, is that preventative planning allows you more choices. Anytime we can do planning before an emergency happens is going to be the best option. It doesn't mean we can't plan during an emergency, but it is a lot easier and a lot better for you if we're planning when you still have the full control and full ability to make your own choices. So again, if long-term skilled nursing is a concern for you or your family, do come and talk to us before you're stuck in the emergency situation. If you're already in the middle of that though, again, still come and talk to us because we likely have more options than you could find elsewhere. So let's now go into a few other law updates. So I covered the Medi-Cal one already. There are some updates regarding special needs beneficiaries. So if you have a special needs child or know someone with special needs, do come and talk to us. The two that I'm really going to focus on today are the Secure Act and Proposition 19. So the Secure Act is just something that if you have an IRA or 401k, you need to be aware that the laws regarding beneficiaries did change. Essentially, it says that in almost all situations, a beneficiary who inherits an IRA or a 401k has to withdraw their amount within 10 years after your passing. So this does a few things. One, your beneficiaries need to be aware of the tax consequences and potentially talk to a CPA of their own once they actually inherit that money. But it's also important for you to note so that if you need to start changing how you actually spend or put your money away, you have the ability to do so. We generally work with Lifestyle Financial Services, and they are really good at going through a comprehensive look at your financial planning and seeing how the best methods are going to be executed. Is that still using an IRA or a 401k, or are there now better ways of doing so? Not only for you, but then again, for any beneficiaries. So that's something if you have questions on, we're happy to either talk to you directly or connect you with them if you have more financial based questions. Now, the other one I'm going to focus on is Proposition 19. So Proposition 19 very much impacted how beneficiaries can inherit properties and the benefits of the property tax component. So it used to be that a beneficiary could essentially inherit any home and they didn't need to consider it their primary residence. It just had to pass from a parent to a child, and then they could keep your property taxes. Proposition 19 changed that though, and said the only property that can keep your property taxes is your primary residence. It has to still pass to a child, but that child now also has to consider it their primary residence. So this drastically reduced the ability for beneficiaries to keep the property tax basis that their parents had. Now, the good news is there is language that we can put into your trust to help maximize the ability to still keep those original benefits. So if this is a concern, if you own property in California, you have children, and you think at least one of them would want to own that property and claim it as their residence, absolutely talk to us about this so that we can make sure your trust properly captures the ability to have those benefits. Now, as we wrap up, I'm going to leave us on leaving a lasting legacy. So again, no matter what your financial means may be, you have a legacy that matters, and that legacy should be captured however we're able to help. So that could be a financial legacy. It could fall under emotional legacy. Maybe it's you really want to focus on the morals and values of your family, or just memories, or the recipes that have been passed down from generation to generation. Whatever your legacy looks like, there are ways that we can help guide you. Now, with the financial legacy, that's very straightforward for us to help with. That's your will and your trust. That's connecting you with a financial advisor or planner. That's making sure that your CPA knows to help reduce your taxes as much as possible. It's essentially making sure your money is kept in your pocket and goes where you ultimately want it to. So that one is very straightforward for us to deal with. The one that people don't often realize we can assist with is the emotional legacy. So I mentioned in the beginning that we allow you the power through your trust to leave personal items to whomever you want. This can be a huge impact when it comes to an emotional legacy, because now you can pass things down from generation to generation, or allow someone with an emotional attachment to have something that reminds them of you or some other family member. Now, if you're someone like me, when my grandma passed away, one of the best things I received was some of her recipes. She was a fantastic cook and loved to cook. And so being able to have those recipes to at least try to recreate, and I'm pretty confident she had some secrets that she didn't write down, but being able to try to recreate those, every time I use them, I get to think about her. And so again, these are things that a lot of times people don't know where to start. And so we're able to not only tell you what we personally have experienced, but what clients have done or what they've experienced that have really benefited them. So if you have questions on how do I leave a legacy for my just future generations, for charities, for my alma mater, whatever your legacy looks like, we're able to help at least point you in a direction where you can leave it. Now, I mentioned at the beginning that we were going to cover a lot of information, and we did. So we briefly covered all the documents that every adult should need, but we also talked about the fact that the plan you originally set up is likely going to change throughout your life's journey. But the biggest thing is plan when you can to avoid any unnecessary legal emergencies, situations, or nightmares. I cannot emphasize that strongly enough. The worst situations that we deal with in our administration department or our litigation department are those that we know could have been so easily avoided. So if you have questions, absolutely come and talk to us. Now, we hope that you want to work with us after all of this. What I will say to that is if for some reason we are not the right fit, I absolutely encourage you to make sure that you vet whichever law firm you ultimately want to work with, because you need an attorney that actually considers what matters most to you, who is going to be the appropriate person to be your successor trustee or your beneficiary. How do you make sure that while you're alive and well, we're really protecting you and your future? How do we make sure that you are maintaining that estate plan? One of the best ways that we connect with our clients are through these education events. And so one thing that you will never have to worry about when working with Koppenberger is how do I get a hold of them, or what is going on in the law right now? We are consistently and continuously in contact with our clients to make sure that they know what's going on and to remind them that if they need anything, we are here for them. So we stand out in so many different ways, but in a lot of ways, it comes down to who we have working with us. So we have 7 full-time attorneys, an attorney of counsel, and actually an attorney who is also a CPA. We also have a staff of about 40 people. What that means is we're able to assist more quickly and a lot of times a greater number of clients than almost any other firm in California at this point. We also have attorneys that very much value continuing their own education so that we can then educate our clients. Some of the ways we have done that is we have attorneys with certified specialties, which means they essentially had to take another bar in specialized areas of law. And then we have numerous attorneys who have gone on to get advanced tax degrees. The reason we're so passionate about this, again, is so that we have the ability to educate you and keep you up to date on what's going on. So if you have any questions on anything that I've talked about, please come and talk to us. You can either give us a call to schedule an appointment, you can visit us on our website, you can email us, you can put something in the chat. We would love to be able to work with and help you. Now, because you sat through today and listened to me talk for about an hour, that means you do get a free consultation. So if you want to meet with us, there is going to be no charge. You can just mention that you attended the webinar today. So thank you so much for attending today. I really appreciate you taking the time to sit with me for this hour in the morning. I hope you have a wonderful rest of your day, and I look forward to working with each of you. Thank you.